looking to buy a property? Are you looking to buy a home or some commercial real estate? It could be an apartment, it could be agricultural land, it could be a villa and so on. Are you trying to understand what are the top 10 clauses that must be there in every agreement of sale? If that's what you're looking for, then you're in the right place, because in this video, I'm going to be talking about the top 10 clauses that must find place in every agreement of sale. Make sure you stick to the end, because the number one clause is where I see most of the problems that creep up between the parties. Hello everyone, my name is Ramana Reddy and I'm a practicing lawyer in the High Court of Telangana. On this channel, I help you by simplifying complex legal concepts. For tips, tricks and more legal information, make sure to hit the subscribe button below. Before we talk about what are the clauses that must find place in an agreement of sale, let us talk about why should you even enter into an agreement of sale? Because, in the eyes of law, even an oral agreement of sale is valid. There is no bar, that it has to be written. So in such a case, why should you even bother with top 10 clauses or whatever as to why even write the agreement of sale? Let's say you're the buyer, right? And let's say that you've agreed to purchase a particular property for 2 crores and you've given an advance of 1 crore and this balance of 1 crore, right? Now you give the 1 crore, the advance, along with the agreement of sale. Now let's say that after you give the first 1 crore, the property value appreciates and there is no agreement of sale. Hopefully you've done a bank transaction, a cash receipt. That's going to be even harder to prove that you even gave the money, to begin with. But even in such a situation, the seller could come and argue, he's not going to say that the property prices have increased, but what he will say is, this was just given to me for a particular service that I was supposed to deliver. This was just given to me as a loan which I had to repay. And, he may come up with all kinds of creative ways to avoid the agreement of sale altogether, or to avoid the sale altogether. And he may just say, I'll refund the money, you can take the money back, but you're not going to get the property. So if you are interested in a particular property, it is always advisable to have a written agreement of sale. An oral agreement of sale, while it is valid in law, that is not an easy thing to prove in court during the course of a trial. So it is always advisable to have something in writing. Now with that out of the way, let us talk about the 10 clauses that must find place in every agreement of sale. Clause number 10. Now if you are the buyer, what you're really looking for by entering into this agreement of sale is that you want 3 things from the seller. Number 1, you want him to transfer the right, title and interest in the property. Number 2, you want him to transfer vacant possession of the property, because it's not, I have a piece of paper that says, that I am the owner of a particular property, but if I don't have possession, what's the point of that? I can't enjoy the property. So you want right, title and interest in the property. You want vacant physical possession of the property. And number 3, what you want is you want the seller, once the sale is concluded, once you actually pay the 2 crores, you want the seller to hand over the link documents and the sale deeds. So, you don't want to be in a situation where you have bought the property, but the original copy of the sale deed or the original copy of the link documents as to how the seller acquired the property. You don't want to be in a situation where you don't have copies of these originals, because the seller can do a lot of mischief if he has the original sale deeds with him, even though you have purchased the property. So it is important to say in the agreement of sale itself that not only will you transfer right, title and interest in the property, not only will you transfer vacant physical possession of the property, but number 3, you will also hand over the original documents and all documents related to this property to me once the sale is concluded, that is, once the sale deed happens. Now, clause number 9. Now, in clause number 9, one thing that you must definitely include is what is the consideration, or that's just a fancy word for what is the total price that you're paying for the particular property. So let's say, in our example, the value of the property is 2 crores. Advance that you're paying along with the agreement of sale is 1 crore. The balance sale consideration is 1 crore. So those are 3 things to have. The advance sale consideration, which is 1 crore. The balance sale consideration is 1 crore. The total sale consideration is 3 crores. So these are 3 things that you must have in the agreement of sale. And I'll give you a tip here. If you're the buyer right? One thing to also include your bank account details. Because believe it or not, like I've seen a particular case where the seller has taken the advance sale money, which is like say 1 crore, and there's a particular time frame in which he has to execute the particular sale deed, and he doesn't do that, and then once a legal notice is issued as to why are you not coming forward for either executing the document or returning the money, the reason he gives is, well, I don't know which bank account to transfer it to, so therefore I have not transferred it so far, which is a pretty flimsy reason. But just to avoid all that, if you're a buyer, make sure that you include your bank account details in the agreement of sale, so that in case things go bad tomorrow, the seller cannot come and say, well, I don't know your bank account details, therefore I cannot transfer the money back to you. Now, clause number 8 that should be included, it's not more of a clause, but I think this is something that as a person who wants to protect your own interests, because you're buying property, or even if you're a seller for the for that matter of fact, one thing to consider is you may go to a lawyer, and the lawyer may, which I think you absolutely should when you're making such a big investment, but the lawyer may, draft the entire thing. But there are still some things which, as the client, you ought to be taking a look at. So I think the first thing that you should be looking at is the schedule of the property. The schedule of property is basically the last thing that will come in the agreement of sale. The schedule just basically talks about what or gives out the details of the property that you're purchasing. Because ultimately you're paying 2 crores, right? So if you're buying a flat for 2 crores, what are you getting in exchange? And you need that in detail. You can't just say I'm buying a flat, right? So you have to say, so all that is piece and parcel of flat number X in B block in, Y society, at measuring say 5,000 square feet, located at so and so city, in so and so mandal, in so and so district, in so and so state, with pin code so and so. Or if it's a house, then you should put in the municipality number that they give you, the house number, and so on. And you should also list out the boundaries. What is to the north of this, the south of this, the east of this, the west of this. This you will find in the sale deed of the seller, because the seller had also purchased the property at some point. So you will find the details of the property in the sale deed, and that is something that you should. The lawyer will take a look at it, but that is something that you should take or do a double check on, just to see what property you are in fact purchasing, because you're paying all this money. You want to be sure that the details are properly spelled out as far as the details of the properties or the property is concerned. And this becomes, I think, more important for say for land. Like if you're buying agricultural land, if you're buying open land, or if you're buying a plot, then we see a lot of these boundary disputes as to what where does it start, where does it end. And in those kind of situations, the boundaries of the particular property mentioned in the sale deeds or in the agreement of sale, those things are focused on those details. So you want to make sure that you get the boundaries and the details of the properties right. The other thing that I think a client or a purchaser or a buyer or whoever you are, other thing that I think that you're responsible for, or you should be responsible for, is the numbers. And the numbers could include, advance sale consideration, balance sale consideration, total sale consideration, which is how much price you're paying, the dates, or what is the date on which. So the in the beginning of the agreement of sale, you will say, whereas the seller is the owner of this particular property because he purchased it through sale deed dated so and so. That date is a number. That is something that you need to look at. Then it will say the sale deed dated so and so, bearing sale deed number so and so. You need to check the number as to is that correct, because you don't want any errors in the document. The lawyer will do a check, but as a party, I think it is something that you should look at. This is what I tell all my clients, that please just double check the numbers in the document, which includes prices, dates, and age. What is the age? Like you say, I, Ramana Reddy, am selling this property to you. I am age so and so, you are age so and so. So you need to make sure that you get the ages right, the addresses right, in the addresses, flat number so and so, and all that. So make sure that you get all the numbers right. Clause number 7 is the timeline. At how long is the period between the agreement of sale and the sale deed? we know what is the period in which this sale deed is going to be entered into. So let's go back to our example. So, you've paid 1 crore, you have to pay a balance of 1 crore. And upon receipt of the entire 2 crores, he or she, the seller, will transfer the property to you. So let's say you enter into the agreement of sale on the 1st of January. How long do you have until the sale deed ought to be registered in your name? How long do you have to pay the money? And it is important to give a time frame within which the whole sale will be concluded, because you don't want the sale to drag on forever. Because as the seller, you may be looking at buying another property after taking money from the purchaser. So it may be important for you that this sale is done in a timely manner. If you're the buyer, then you may be, moving cities. You may want to move in there, and you may have a tenant at hand who's ready. All these things. So you want to get a proper timeline in which the entire sale, which is the sale deed, has to be executed and money has to be paid. So for example, you can say we are entering into this particular agreement of sale on the 1st of January. We have until the 31st of March to conclude the sale. So, that's a specific time frame. Now, there are cases where, it doesn't happen, and whether time is of the essence of the agreement of sale, that's a phrase that is commonly used. Whether time was key, and, what is the consequences of not doing that in time, that's a topic for a separate video. You can click above, where I will post that particular link as to what happens if the sale deed is not done. Now, clause number 6 that must be there in every agreement of sale is that you take a representation. If you're the buyer, you take a representation from the seller. A representation is basically like a statement. So you take a statement from the seller that he is in fact the owner and possessor of this particular property. I mean, I've seen the papers, but I want you to put it in writing that you are the owner and the possessor of this particular property. You will also take a representation, have clear and marketable title in the particular property, and also that there are no loans or there are no property taxes that are due. So let's run down a couple of situations. If you're buying an apartment or a villa, you will take a representation that that there are no dues to the society, that all the electricity bill, water bills, all these are paid. If they're not paid, then they will be paid by the date of the sale deed. If you're buying agricultural land, especially in Telangana, then you want to take a representation from the seller saying that protected tenants in the particular property, that this is not property that is owned by the Waqf board, and so on, because these things are hard to trace, because especially if you're buying agricultural land, you're pretty much on your own because you're just buying vacant land. So you want to make sure that you take these proper representations. If you're buying an independent house or any kind of building, you want to make sure that you take a representation from the seller that that you've obtained a building permission from the municipality, that you've obtained an occupancy certificate from the municipality, that the building is compliant with all the local municipal laws. You also want to take a representation that the property is not in any unauthorized layout. So basically, what you want from the seller under this clause is that the seller represents that there are no encumbrances on the property. By encumbrances, I mean that there is nothing that burdens the property in a way that prevents you from enjoyment of that particular property, or that after you've bought the property, now you're facing all these problems. So you want to take a representation from him, which is basically like a statement from him that all these things have been complied with, so that you don't have to bother with all these headaches. Now, clause number 5, and this applies more so if you're a buyer, then an important clause to put in is that, let's say you enter into the agreement of sale on the 1st of January, we have until the 31st of March, right, to do the sale deed. Now, if you are ready as the buyer to pay the seller, then the seller should technically do it by the 31st of March. If he does not do so, then you need to put in a clause that says that for every day that you delay, there will be a daily penalty of 2,000 rupees or 3,000 rupees and so and so. Just to, make the seller aware that if you delay in handing over the possession to me by that particular date, by the 31st of March, then there will be consequences. This kind of prefixing damages is something called liquidated damages, which is acceptable in law. Just make sure that the amount of penalty that put in the agreement of sale, let that not be like, a prohibitive amount, like, 1 lakh per day, 2 lakh per day. It could be like a commercial kind of building or lease, but make sure that you don't make it as exorbitant because in that case, courts may not uphold it. Now, clause number 4 is that you want, if you're the buyer again, you want to take something called an indemnity from the seller, which basically means that let's say tomorrow after you enter into the sale deed on the 31st of March, or even in between, after the agreement of sale, the seller has made a representation to you that he has clear and marketable title, but after that you find out that there's a third party guy who's coming and is filing cases against you, against the person who's agreed to sell the property to you. In that case, you want to tell the seller that, look, it's your property, I have nothing to do with it. If there is a defect in the title for some reason, or if some third party comes to want, if he wants to come and fight me over this, then you have to step in and you need to protect me in that litigation. You need to cover my court costs, my lawyer costs, my legal fee, and you need to step up and you need to make sure that person goes away and that you will defend me like you will defend yourself. And that is something called indemnity, where 100% of whatever costs that I have to bear to enforce this agreement of sale against a third party, or after doing the sale deed, if a third party comes to me, then you will be responsible for it. So that's another clause to include in an agreement of sale. Now, clause number 3, you need to say that there cannot be any assignment of this particular agreement of sale. So what does that mean? So let's say that you're the seller, right? And you meet Mr. X who wants to come and buy from you. You actually meet him and you know that, that he looks like a good guy. And you take 1 crore from him and there's another balance 1 crore that's payable on by the 31st of March. Now, on the 1st of February, he comes and tells you, you know what, I have all the rights that I had in this particular property by virtue of paying this 1 crore. I have given it to my brother. So my brother will now come and do the deal with you. Now, as the seller, I'm worried, who is this brother? I've never met him. Will he pay the balance sale consideration, or will he honor the timelines? I don't know. So as the seller, you want to protect yourself by saying that, look, if you would like to, you can assign this particular agreement of sale, but only with my consent. Only when I'm okay with it, you can, because I want to meet that person first. And if I feel like, okay, this person is also, a legit person, then in that case, you can. But otherwise, you can't just go and assign this particular agreement of sale to anybody you want. On the other hand, if you're a buyer, then, well, I guess you don't have that problem because the seller is the owner of the particular property. So there's no situation in which he will be able to assign the particular property without selling it, which we are trying to prevent with this agreement of sale. So that will not be a problem for you if you are the buyer. But that leads in to my next point, which is clause number 2, which is, if you are the buyer, then you want to, put in a clause that says that between the 1st of January and the 31st of March, there will be no new transaction. You cannot, or you, the seller, you cannot go and find a third party person and enter into a fresh agreement of sale with him, or that you cannot go and mortgage the particular property to a bank and take money, or that you cannot somehow, I guess the legal word is encumber the property, that you cannot somehow burden the property and get it to a worse situation than it is today. So you will say that there are no new transactions that can happen between now and the time of the sale deed. This may sound obvious, but it is an important clause to put in. And also, on a related note, it is also important that once you enter into this agreement of sale, then you give out a public notice. So the public notice will say, I so-and-so have purchased this particular property, or I've entered into an agreement of sale with the seller for this particular property. And you need to publish that in a local newspaper. Not that any interested party he may or may not look at the particular news. But what is important is that you are showing to the world, and hopefully if you don't have to go there, but if you have to, then even to the court, that you are a bona fide purchaser, that you are a purchaser who in good faith, that you have done your due diligence, that you've done everything you could to protect your interest. So that paper publication will help you in the future. I don't want to get into it right now, but there's a concept in law called bona fide purchaser for value, and they are held at a higher pedestal. So just to take that advantage, I think it's important that once you enter into an agreement of sale, also issue a public notice. Now, clause number 1. So this is a clause where I see a lot of problems that come up between the parties, especially if the agreement of sale is not honored, which is termination and refund. So let's talk about termination first. So let's say that you are the buyer, right? You've looked at all the papers and of the property papers, and you are satisfied. Now you pay 1 crore to the seller. You take all the related property papers and you want to take a bank loan, for example. You take the papers and you go to a bank and you say, I want a loan. Here are the property papers, you can check. Now, the bank lawyer checks and he's like, you know what, there are these 3 problems in the title to this particular property. So therefore, I am not, we can't give you a loan. You try 5 banks, same problem. Now, in such a situation, you want to be able to go back to the seller and say, look, there's apparently a defect with this particular property. I want my money back. I'm happy to cancel the entire agreement of sale, but I want my money back. So as a buyer, it is important that in such a situation, you want to terminate the agreement of sale and you want to get out. But if you find problems with the title of the property, the other scenario could be where the seller, for some unforeseen reason, says, I cannot proceed with the agreement of sale. Now you want to retain the right either to sue for specific performance, which I'll talk about, but you can either sue for specific performance of the agreement of sale, or you want to get a refund of the money that is already paid. And that choice should lie with you. Specific performance basically is a type of suit that you file where you go to the court and you seek a direction from the court to the seller to come forward and register the sale deed, because I've already paid advance money. He has an obligation to come and do the sale deed. So so you want to retain the option either to go to court and enforce the agreement of sale, or say, what, if you're not interested, just give me my money back and give me with interest. So there's a monthly interest of X%, say 2%. So you were supposed to repay by, obviously you're supposed to do the deal by the 31st of March. Since you've not done it, now we are on April, 30th of April. So for this 1 month, you pay me interest, give me money back, we're good. I will cancel it, I'll go look for another property. You want to be able to retain the right to choose which remedy you want to go for. On the other hand, if you are the seller and you may have, you may want to take the 2 crores here from the purchaser and you may want to invest that money in another property. So it is important for you that even that the deal closes. Now, in a situation where the buyer is not coming forward to honor the sale deed or to honor the agreement of sale or to pay the extra 1 crore, you could have a clause that says, you know what, if you don't pay me, then I'm just going to forfeit the one crore that you paid me as penalty. You're not going to see anything from that. So that's just a way for, to ensure that as the seller, that you have an upper hand to make sure that the deal is concluded in a timely manner. I hope the video was helpful. If you need more information, make sure to click the link in the description below.